be undertaken by the National Court.
As I understand it, the Lord Advocate, in his intervention, is challenging that proposition.
Yes, he is, my Lord. But of course, the respondent is not challenging that proposition. Now, my Lord, I don't know whether the message reached you. We received the Lord Advocate's submissions very late in the day, and I have asked to be allowed to reply to them in writing later.
Yes, well, if this had been a live issue, so far as anyone in this court was concerned, I think we would have wanted to hear some oral argument about it, because I understand it. It's not.
I don't understand it to be challenged by the respondent. So, my Lord, I'm in your Lordship's hands as to whether you would like a short note from us on the topic.
I think that would be helpful.
But I mean, all you're going to say is that in Andrew, the Lord Advocate say that the Article and Article 6 designation is conclusive.
And we say that's wrong.
You say it's wrong.
We say it's wrong as a matter of statutory construction in the 2003 Act, and we also say it's wrong to suggest that the principle of mutual confidence compels that result. And in that regard, we rely on the recent decision of the ECJ in NS, which is the decision under the Fundamental Charter of Fundamental Rights, dealing with extradition to Greece, which overrules the decision of the House of Lords called a case called KRF. But I can put in a short note on this topic. It's interesting at paragraph 47 that the Divisional Court accepts without hesitation here that a warrant issued by a Ministry of Justice would not be a valid warrant under Part 1. And that's interesting for two reasons. Firstly, because, as this court has seen, there are a number of member states that have designated their ministries of justice to issue warrants, which indicates that the implementation of this decision is not satisfactory. Secondly, it's interesting because it invites the question, why does the Divisional Court have so little difficulty in concluding correctly that the Ministry of Justice is not a judicial authority? And the reason in my submission is that it is incompatible with the notion of what a judicial authority is, that a judicial authority should be a branch of the executive. The essence of judicial authority is independence from the executive. But once one accepts that, one cannot escape from the second half of the equation, which is that it is equally of the essence of judicial authority that the judge is independent of the parties. And the nemo judex rule.
Sorry. And the reasons they give in the middle of paragraph 47 is it would self-evidently not have been issued on principles universally.
Yes, accepted in Europe.
And that is the reason.
Yes.
And that's one you embrace wholeheartedly.
That is, and indeed, my Lord, it's the point that at the outset of my submission I said really is the beginning and end of this case. It is a principle universally accepted in Europe and for over 1,500 years.
But if you look at paragraph 36...
Sorry, 36, my Lord.
In their judgment, the last sentence is the key as to what they're referring to as fundamental principles, and I don't see, is there any reference to the principle nemo judex anywhere in this?
No, there isn't, my Lord.
No.
But we submit that it is very difficult to see that principle as in any way less fundamental than the principle of independence from the executive. They are the two key elements of what a judge is.
I also had some difficulty with this proposition that it's only if self-evidently the particular body is not a judicial authority that you go behind the designation.
If you need evidence,
once it's challenged, then surely it must be for the court to consider the merits of the challenge.
Lord, but we respectfully would agree.
I'm sorry, I mean, a public prosecutor you accept who is independent of the executive, but not of the parties. Is that the point?
Well, my Lord, the position will be different in different states. It does appear that there is a decent degree of functional independence for the Swedish public prosecutor from the executive, but that the Swedish public prosecutor performs an adversarial function, which makes her a party. And that was the conclusion of the European Commission on Human Rights in the Swedish case, and we say there's no reason to depart from that. There's no suggestion that that is wrong, that analysis is wrong.
And would it be the same if we designated the CPS?
Yes, my Lord, it's impossible to see how the CPS could be a judicial authority.
Independent of government, but it's a party.
It's a party, yes. And when you look at the type of decision that the prosecutor is being asked to make, in this case, the prosecutor is being asked to exercise a judgment. Is it proportionate to require this man's extradition? in a situation where he has not been charged with any offence, where he is offering voluntarily to be interviewed by video conference, and where he's being required to leave his home and travel overseas. But of course, the prosecutor is the person who's investigating the allegations, and the prosecutor has an interest in wanting him there. And so how can the prosecutor make an impartial decision about whether it's proportionate to extradite him? In no way impugns her good faith. It is a functional problem that a person who's a party cannot be an independent, impartial judge. It's just, it's a basic fact.
Presumably it's not just a question of substantive impartiality, there's also a question of whether they appear to be.
Yes, of course.
Appearing.
Of course, my lord. And your lordship has my references to the Frome case, the Kander and Malaya case, and Pinochet. The principles are so familiar that there's really no need to retread the ground again. And of course, the Nemo Iudex rule is normally invoked in its extended meaning to deal with judges who are either actually biased or, more often, where there is the appearance of bias. But this is the core meaning of the Nemo Iudex rule, that the judge cannot simultaneously be a party. And the Frome case is interesting for that, because that was an analogous situation, that if you've participated in proceedings as a party, you cannot exercise a judicial function in relation to those proceedings. And that's the principle that goes right back to Roman law, on a European and not parochial common law basis.
Where's the reference in Justinian, since you're insistent on it?
My lord, I know, so it's in our case. I obtained it from a textbook. It's tab 167, the supplementary bundle. Miss Law was sent to go and find the original one, and was told by Lincoln's Inn that they had two copies, an old edition and the new edition. When she arrived at the library, she discovered that the old edition was a 14th century manuscript, and the new edition was a 15th century manuscript. That is the reason they have not been photocopied. But the reference is at tab 167 in Latin and in English. If we can just return to the divisional court judgment. We were at paragraph 48, and here the point is simply the role of soccer. And again, we say here the divisional court was right, that the role of soccer is simply to certify that the issuing authority has the function of issuing EAWs. It does not certify it's a judicial authority. The judge, in performing the duties imposed by section 64 and 66, must determine whether the authority is a judicial authority. And so they say it's right that it was raised in the extradition hearing, and we respectfully agree with that. Now then, finally, paragraph 49. And here is a fascinating part of the divisional court's judgment. Because what the divisional court says at paragraph 49 is this: although in our view no challenge can be made to the validity of the EAW issued by the prosecutor, it is necessary to consider whether the EAW should be accorded more intense scrutiny as a warrant issued by a party to the proceedings. That might be the case where it had not been subject to the impartial scrutiny of a judge in the member state of issue. Although a prosecutor would ordinarily act independently in the decision to issue the EAW, and in pursuance of what would in the terms of the framework decision be regarded as a judicial function, the decision is that of a party to the proceedings which has not been subjected to the impartial scrutiny of a judge. It would therefore be entirely in conformity with the principles of mutual recognition and the promotion of mutual confidence between judges and citizens to recognise that circumstances can arise in respect of an EAW issued by a prosecutor as distinct from a judge, where it's necessary for a court to accord more intense scrutiny to such a warrant. Mutual confidence, particularly the confidence of citizens in the operation of the EAW system, is not enhanced by according to such an EAW the deference that would ordinarily be accorded to an EAW issued by a judge, who is bound to take into account the interests of both parties to the proceedings. Now, we say that is a fascinating and revealing passage, because it shows the judge's deep unease with the notion that the party is the judge. But since he is determined to uphold the validity of the warrant, he seeks to extricate himself from his difficulty by dealing with it by suggesting a more intense standard of scrutiny. But what he's actually expressing here is that this is not a valid Part 1 warrant. It's not in accordance with the safeguards which the United Kingdom Parliament concluded were necessary in order to ensure the maintenance of mutual trust and confidence in the operation of this system.
I mean, what sort of things do you think they had in mind? Because I'm not quite sure what matters would be subject to more intense scrutiny here
it's
than would...
It's an extraordinary proposition and demonstrates the incoherence of the divisional court's approach. Of course, we've already seen from the House of Lords that complexity and lack of certainty are to be deplored in the operation of this regime. And yet the approach for which the divisional court contends is calculated to lead to uncertainty. And of course, we submit the same is true of the approach of the respondent on this appeal, because the respondent on this appeal, with respect, has offered no coherent principle by which you would distinguish a judicial from a non-judicial authority. There is no clear test set out anywhere, either in the divisional court judgment or in Miss Montgomery's printed case. Then at paragraph 51, there is the point about the Svea Court of Appeal, and your Lordships already have my submission on that the Svea Court of Appeal has not in any way endorsed the issue of an EAW. The Svea Court of Appeal has taken a different decision to uphold a detention order that is not the same as an order for extradition, not the same as an EAW.
If the court had approved the issue, then I suspect you'll be standing on a rather technical point. Nonetheless, it was still issued by the wrong body.
Yes, yes. But that is not the situation in this case. My lords, my lady, unless I can be of any further assistance, those are the submissions for the appellant, and we invite the court to allow the appeal.
Thank you very much. Mr. Summers?
I'm sorry, can I just be... What? Sorry. Can I just be clear? Paragraph 28, Statement of Facts and Issues. I mean, yes. What did the Court of Appeal in Sweden decide? That the domestic arrest was proportionate?
The Svea Court of Appeal upheld the order, a domestic detention order.
I know.
Yes.
What does that mean? I mean, were they alive to the fact that he wasn't there and that they'd be applying for an EAW and all the rest of it?
Well, the Svea Court of Appeal was not concerned with the question whether he should be extradited. Simply concerned with the question whether, if he was in Sweden, he should be detained.
A domestic detention order in absentia is not something that...
no, well, it means if he enters the country, he can be arrested. But the Svea Court of Appeal was not deciding or purporting to make any decision about the issue of an EAW, or whether such a course would be proportionate. That was a decision that was for the prosecutor.
I mean, you were saying half an hour ago, by agreement, apparently, that it's routine in the Swedish case that there will be a domestic detention order before an EAW is applied for.
Yes, but also, my lord, as we saw from the Swedish evaluation report, there is a separate exercise of discretion that must be taken by the Swedish prosecutor, which is whether the EAW will be proportionate, looking at all the circumstances, including the personal circumstances of the individual, their family situation, the seriousness of the offence, a range of factors, the age of the individual, and so on. So it's a completely separate exercise of discretion from that which was undertaken by the Svea Court of Appeal.
I follow that. But all we take, therefore, from the Court of Appeal's decision is that they thought that for the purposes of a domestic detention, there was enough in the way of reasonable suspicion.
That's right, that he could be detained in Sweden.
Of the offences, and they reduced the level of one of them.
Yes, that's correct, Lord.
Okay, thank you.
are there any other